There is this book, although I'm sure it's online now, but back in the day, we had this Black's Law Dictionary, and it was actually pretty helpful. I haven't opened it in a long time. I opened it today so I could teach you about motions. I wanted to get the actual definition, and no, I'm not talking about the act of moving. I'm talking about a court motion, a written or oral application requesting a court to make a specified ruling or order. Motions used to occur a lot more in personal injury than they do now, in my experience, but I think that's because there's such a backlog in the courts in Toronto, which is a separate topic and probably one where I shouldn't get started talking about because I won't stop because it's really frustrating. But it used to be that you could threaten motions all the time and get motion dates really easily, and in fact, in certain jurisdictions, you would just put in whatever date. In Newmarket, I used to be there every Tuesday and Thursday arguing motions. Just put my date in, be on a list with 150 other people, hang out with all the other junior associates and, I don't know, get to know them, have fun. It's not like that anymore. No fun time. Most of the motions are done virtually, but putting that aside, you are scheduling your motions and getting a motion date at the Toronto court. If you are, for example, asking to be removed as lawyer of record, they often tell me they don't have dates available, which is frustrating, and to check back during the first week of the following month. They are scheduling them out, 8 months, 10 months away, which is really frustrating because it delays the case when you have a motion date that far down the line, because usually you're trying to do something for your case. That's the whole purpose of a motion. You're asking for something to be done. Common motions, at least in personal injury, motion for substitute service. So if you've been unable to serve someone with the statement of claim, which is necessary in order for the file to keep going, for defense to be obtained, then you are bringing a motion for subservice. So you're going to do substitute service, meaning in personal injury again, we're going to serve the insurance company instead of the defendant because we can't locate the defendant, or maybe the defendant moved away to some remote area and no one knows where he is. So that is motion for subservice. Then we have motion to amend the statement of claim. So for example, I just did this yesterday. A former junior associate put the wrong date of loss. What is date of loss? That is the date of the incident. So they put the wrong date. They put August 21st instead of July 21st. So I can't just go and change that myself. I have to either do it by requisition, meaning ask the registrar at the court to do it if it's on consent and you're not changing the title of proceedings, meaning the plaintiffs or the defendants. Then you can do it on requisition. Again, if it's on consent or pleadings haven't closed. Pleadings haven't closed, meaning there's no defense yet, so it's still open. Or you can do it by motion. So if we have gone through the proceedings and we realize, oh, we need to amend the statement of claim, then you have to bring a motion to do that, to make a formal amendment. And then the amendments in the statement of claim that you've drafted are all underlined. So you put amended statement of claim on your first page, and the word amended is underlined, as are all the changes that you've made. You're going to strike through what you don't want, and you're going to underline all the additions. If you make a second amendment, it's going to be amended statement of claim, and then that word second, like the first one in that whole chain, but that's going to have a double underline under the word amended, and every change in the statement of claim that you've made at that point is going to have a double underline. That's how you denote between the original, the first amendment, the second amendment, and it's going to keep going for however many times, except at some point someone's going to say, well, this is a mess. I don't understand any of this. And then you do a fresh as amended statement of claim. And that's going to have no underlines. It's called fresh as amended statement of claim. And everyone knows that there were amendments made and it was probably a mess. And if someone wants to look at that, you can look at that. But people generally don't. Why would they? So we went on and on motions for amendments, but there are motions for basically everything you want to do. You need a court order. If you are representing a client and you can't represent them anymore for whatever reason, If they don't either retain another lawyer who must serve a notice of change of lawyer and be formally on the record, or this client does not serve a notice of intention to act in person, so represent themselves, then you must formally request the court to permit you to be removed as lawyer of record. And that requires a court order. And to get the court order, you must bring a motion. I could go on and on about motions, but I think you get the point. That is motion.